In 2025, the landscape of U.S. immigration is more complex than ever, especially with Donald Trump back in the White House and major changes being enforced. For students currently in the United States on F1 or F2 visas, this raises critical questions. Can they become permanent residents? Can they apply for a green card? And if they succeed, how do they protect that green card under these strict immigration policies? This video breaks it all down. Whether you're an F1 visa holder here for education or an F2 dependent spouse or child, we'll explore every available pathway to lawful permanent residency and how to safeguard your future in America during this challenging political era. Let's begin by understanding what the F1 and F2 visas are. The F1 visa is issued to international students who come to the United States for full-time academic study. It's a non-immigrant visa, meaning it's temporary and doesn't provide a direct route to a green card. The F2 visa is issued to the dependents, spouses, and children of F1 visa holders. These dependents cannot work or study freely and are fully tied to the status of the F1 principal. So, while F1 and F2 provide legal entry and stay, they are not designed for long-term immigration, but with the right steps, they can still lead to a green card. One of the most common and effective paths from F1 or F2 to a green card is through family-based sponsorship. If an F1 or F2 visa holder marries a U.S. citizen, they can apply for permanent residency by filing Form Y-130 and Form Y-485. Marriage to a U.S. citizen places you in the immediate relative category, which means you don't have to wait for a visa number to become available. The adjustment of status process typically takes 12 to 18 months and includes a background check, medical examination, and an in-person interview. This route is especially effective for those who are already in the U.S., as it allows them to apply without leaving the country. The F2 visa holder, as a dependent, can also apply independently if they marry a U.S. citizen or lawful permanent resident. Another possible route is employer-sponsored immigration. After completing your degree, F1 students may apply for optional practical training, which allows them to work in the U.S. for up to 12 months, or up to 36 months for certain STEM fields. During OPT, if an employer is willing to retain you, they may file an H-1B petition. Once approved, you can work in the U.S. under this non-immigrant work visa. If that employment continues and the company wants to sponsor you permanently, they can file a green card petition under the EB-2 or EB-3 employment-based categories. This path can take several years, but remains a strong option for students who build a valuable career track. Some exceptional individuals may qualify for the EB-1 or EB-2 National Interest Waiver categories. These are reserved for people with extraordinary ability in sciences, arts, education, business, or athletics, or whose work is deemed to be in the national interest of the United States. Unlike other categories, these do not always require a job offer or labor certification. However, they do require strong evidence, including awards, published research, media recognition, or significant contributions to your field. For those coming from eligible countries, the Diversity Visa Lottery is another potential route. If selected, you can apply for a green card while in the U.S. as long as you're maintaining valid status. The selection process is random, and while the odds are low, thousands of people every year receive green cards through this program. Just remember, applying doesn't affect your current visa, and it's completely free to enter. Once you determine the path you're eligible for, the next step is adjusting your status. This means filing Form Y-485 if you're currently inside the U.S. in legal status. The form initiates your green card application and allows you to remain in the country while it's processed. Alongside I-485, You can also apply for work authorization using Form I-765 and advance parole using Form I-131, which will allow you to work and travel while your application is pending. It's critical that you don't fall out of legal status during this time. Missing deadlines, working without authorization, or failing to maintain full-time studies can lead to a denial. For F2 visa holders, things are a bit trickier. Since F2s are dependents, they cannot work and have limited educational options. If the principal F1 visa holder loses status, the F2 status also ends. This means F2 holders should aim to establish independent eligibility as early as possible. For example, if an F2 visa holder marries a U.S. citizen or is eligible for a green card through other means, they should begin the process independently without relying solely on the F1's status. Now, let's shift to the more urgent topic: how to protect your green card under the Trump administration in 2025. Trump's return has brought aggressive immigration enforcement policies, many of which are revivals of earlier executive orders with stricter applications. One major area of concern is the public charge rule. While under the Biden administration, the rule was relaxed, Trump's team has reinstated stricter versions. This means green card holders who rely on government benefits like food stamps, Medicaid, or housing vouchers may face difficulty renewing their green card or becoming naturalized citizens. Even applying for such benefits could trigger scrutiny. It is advisable to stay financially self-sufficient and keep a clean public record. Travel restrictions are also back in place for certain countries. While green card holders are generally exempt from bans, excessive travel to high-risk countries or returning from a flagged nation could trigger secondary inspections or entry denials. You should always carry proof of your U.S. ties: employment letters, utility bills, lease agreements, and tax returns when returning to the U.S. from abroad. Perhaps the most dangerous threat to your green card under Trump in 2025 is the increased focus on criminal records and arrests. The Lachen-Riley Act, passed in early 2025, mandates that non-citizens arrested, even without being convicted, can be placed in deportation proceedings. This law gives ICE more power to detain immigrants, including green card holders, if they are merely accused of certain crimes, especially theft, assault, or offenses involving moral turpitude. To protect yourself, avoid any legal trouble, no matter how minor. Even a traffic stop that leads to a misdemeanor charge could cause immigration issues under current enforcement priorities. There's also the matter of increased registration and surveillance. Some immigrant communities are being required to register with the Department of Homeland Security under new monitoring programs. If you receive such a notice, do not ignore it. Failing to comply could result in fines, detainment, or revocation of your green card. Always respond to official USCIS or DHS communications promptly, and consult an attorney if unsure. As for those planning to naturalize and become U.S. citizens, expect delays and additional scrutiny. Trump's administration is closely reviewing naturalization applications for fraud, prior immigration violations, and any criminal or public charge issues. Keep detailed records of all your visa history, tax filings, employment documents, and lawful entries and exits from the U.S. Now let's review common mistakes that you must avoid. First, don't overstay your F1 or F2 visa without taking legal steps toward status adjustment. If your OPT ends and your employer isn't sponsoring you, you must leave the U.S. or change your status. Second, never submit fraudulent documents such as fake marriage certificates or job offers. USCIS has ramped up fraud detection units, and the consequences are severe, including lifetime bans. Third, don't miss USCIS appointments like biometrics or interviews. Reschedule if necessary, but never ignore official notifications. To stay protected, You must act early and act smart. Consult an immigration attorney to develop a long-term plan. Keep your immigration documents safe and up to date. Avoid any public benefits that may trigger public charge concerns. Don't travel without legal re-entry permits, and never let your status lapse. In summary, yes, it is still possible in 2025 to go from an F1 or F2 visa to a green card. Marriage to a U.S. citizen, employer sponsorship, national interest waivers, and even the green card lottery all remain valid options. But the political climate is harsh, and green card holders must be extremely cautious under Trump's policies. Aggressive enforcement, expanded deportation rules, and travel restrictions are all real threats. Yet with the right legal guidance, attention to detail, and a commitment to staying informed and lawful, you can still achieve your goal of becoming a permanent resident and even a citizen in the United States. Stay safe, stay aware, and take action early. If you found this guide helpful, be sure to subscribe for more immigration updates, tips, and real stories from people just like you. This is your future, and you deserve to understand every step of the journey.